Good afternoon, everyone. Thank you so much for joining us for this webinar. And myself and Anthony Schwastik and Aaron Hoffman, who's had a small issue and should be joining us, are here to talk to you about issues relating to businesses and protection of businesses in divorce and in other areas. And so I am a family law practitioner, a divorce lawyer with Cohen Seglius in the Newark, New Jersey office. Anthony is with Cohen Seglius in the Philadelphia office. And so he handles, Anthony, why don't you tell them a little bit about you and what you handle in your type of work?
Absolutely. So I'm a sort of a general business lawyer. At our department, we handle basically full service, the corporate real estate, IP, commercial transaction, whatever else you need for our business clients. So this includes information, reorganizations, dissolutions, large transactions such as mergers, acquisitions. We do equity compensation, spinoffs, whatever you can think of. On the real estate side, we do acquisitions, sales, leasing from both landlord and tenant side, enforcement, and defense of clients who might be, who might have a dispute with their landlords. And on IP, we do kind of what you would consider more of a soft IP approach. So any copyrights or trademark branding work you might need, we assist there. So chances are, if you have a question, we can answer it.
Great. So why don't we get started and just talk about a few things. Let's talk about, to start with, prenuptial agreements. And so prenuptial agreements are agreements that are entered into by the parties prior to their getting married, and you can include a number of provisions with respect to your business in a prenuptial agreement that will assist in how that business is valued and or divided or exempt from distribution upon divorce. So let's talk about a little bit of those ideas and areas. So Anthony, jump in whenever you think appropriate.
Absolutely.
So one of the things that you can do in a prenuptial agreement, and why I like them, particularly if there's a business involved, is because you can define in the prenuptial agreement the idea that the parties are going to attend arbitration instead of ending up in the courts in the event there's an issue with respect to anything in the prenuptial agreement. That is particularly helpful because you can select your own arbitrator, who is hopefully a lawyer with many years of experience in family. And you can also add in a business lawyer and or potentially a forensic expert to be the judge or the arbitrator in your matters. And those are people who typically have a significant more experience than what you might find with a judge who may never have practiced in this area or have been involved in business valuations. And so that is, I think, one of the first benefits that you get if you are going to be able to have a way to determine the businesses or the values of the businesses in a way that keeps everything out of court. The other benefit there is that it maintains privacy for everybody involved. Arbitration is not subject to disclosure or discussions in the court. Nothing is filed with the court. And so the idea is that anything relating to the businesses is going to be kept private within that forum, within the arbitration, and the parties can agree that it will remain private and confidential so that they can feel free to discuss issues that may be relevant to the business that perhaps they don't want third parties to know. Another idea that you can utilize and discuss in a prenuptial agreement is the idea that you can allow for a determination of how value is going to be determined. So instead of saying, great, we have a business and we are going to simply agree that we're going to go to arbitration, you can put into a prenuptial agreement the methodology and how you are going to value that business upon a potential dissolution of the marriage. This can save a lot of time and money for people because the parties can agree at the outset, before they're in the emotional throes of a divorce, how they best want to determine the value of a business. What does that mean? Well, instead of doing a full-blown calculation, a full-blown audited valuation, which is a very expensive endeavor and rarely used in family, but can be, if particularly if there's going to be a trial, the parties can agree that they will have a calculation of value that is done by the experts or an expert. And that is a much less expensive. They can agree to do schedules, just do schedules as to what valuation would be. Don't even do a complete report, which can save the parties significant time and money. If there is a business in existence at the time the parties are getting married, someone should have already done a valuation. Again, the parties can talk about what the valuation is so that you know, particularly in a prenuptial agreement, but even if there isn't one and one party solely owns the business and is going to seek to keep it, they might be wise to get a valuation at the time they are married, because that will set the value as of the date of marriage. It is an important number to know. But in a prenuptial agreement where the parties have agreed that they have fully and fairly disclosed all the values of assets and debts and their income, that is also particularly helpful and relevant and required. And again, the parties can agree through lawyers, are we doing a full audited valuation? Are we doing a calculation of value? Is there a valuation that was done for this business in connection with potentially seeking funds for investment that exists relatively close to the time that the parties are getting married or entering into a prenuptial agreement? Maybe the parties will agree that that exists. And if there is, and that will suffice, and if there is such an agreement or evaluation, the parties could agree that they are going to return to the company, the person who did the valuation, in the event of a divorce, because that person will certainly have some information already, or they trust that person to do it. And the parties can talk again about what would be necessary to be provided in order for the forensics to do their work. Do they need everything? They can talk through those issues. They can talk about if one party is dissatisfied with the valuation that is calculated, even though the parties have agreed this is what we're going to do. Is that the final decision? In other words, are they agreeing that whatever person they select and whatever methodology they select for valuing the business in the event of a divorce, which is contained in their prenuptial agreement, is that it? There is no, I won't call it a right of appeal because that's not the right answer, but is there a right of the other person or a person who's dissatisfied with that value to go get their own, or is there not? Is that the final say? So all of these provisions can be talked about in a prenuptial agreement, and the parties can agree upon how those issues are addressed. The other thing that the parties could potentially do is if there is, there are partners, maybe there are partners that are involved. Maybe the parties should look at the shareholder agreements or the partnership agreements and determine, have those people already determined a way in which valuations will be done, or what interest they get at different stages of in the existence of the company. In other words, there are companies that determine that upon an age of retirement that the company select, which may not be 65, it could be 60, the parties, the partners, are then going to no longer be entitled to a full equity interest. They are only going to be entitled to maybe a trail out or a buyout in a total amount. Those are things that one should know in terms of dealing with these issues and in a prenuptial agreement. I don't want to be the only one talking. So Anthony, anything you can think of, and at least in the prenuptial agreement area?
No, of course. So look, everything you said about the prenuptial agreement would apply to a standalone operating agreement for an LLC or a partnership agreement to the extent you're using a limited partnership. You should never have a general partnership. So, just get that one out of your head, or a shareholders agreement for a corporation. So, I mean, all the sort of check marks, you basically hit. You're going to want to make sure that you clearly define, number one, what are the, when everyone's happy, of course, what is the price? Because that's the most important. Actually, even more important is, I apologize, I'll take a step back. The most important is what happens upon the occurrence of an event. Do you have to sell your shares? Do you have to step down from your management rights and just be what's called under the New Jersey LLC Act an assignee? Do you have to step down from your board seat? Do you have to step down as a manager or officer? Or, and you're only allowed to participate in either nothing, or you're allowed to participate as you were before, but not on day to day, just large transactions that are brought up to the board, or the managers of an LLC. That's a big consideration. Second, you're gonna, again, as Carolyn said, you're going to see how much. And how do you develop how much? Well, the easy way is always to kind of just dump in determination of fair market value. You do that when you have to sign something because you need a bank loan in 2 days. If you have a well thought out agreement, you're going to want to have some basis for what that business valuation is, because people are going to have wildly different value of the business. When it comes to liquidating those assets, to transferring them, to selling them, it can get a little messy. How is it paid out? Is it paid out in a lump sum? Is it paid out over 5 years with a promissory note? How would we reasonably be able to handle this? And the benefit of New Jersey, PA, Delaware, the benefit is, from a corporate perspective, notwithstanding any sort of wrenches that family law might throw in the gears, from a corporate perspective, you can be extremely flexible in how you handle this. What are you limited to? Well, you're limited to certain matters of good faith. You're limited to to duties of honesty in dealing with your fellow partners, and you're limited to in a very sort of bland way, tax code. So if you're going to set a valuation saying, well, you get everything for $1, if X, Y, and Z happens, the taxing authorities might have an issue with that, because what you're getting is something for value at under fair market value. The Uncle Sam's going to want his cut of that. So, these are just considerations you have. So rather than set a price, the general way around it is to either say fair market value or to establish a methodology. The two things I would say are, the more clarity you have on the front end will save you headaches in the back end. And that's just generally, there's two reasons for that. Number one, clarity on the front end prohibits people from tying you up later on. So as long as you can point to X, Y, and Z, when they're aggrieved later on, if they are aggrieved, hopefully that never happens, they have less arguments to go to their lawyer for, because generally, to the extent, in business, as I assume in family law, to the extent there is any ill will or bad feelings, lawyers can craft all sorts of arguments, based on their interpretations, whether or not strained. But the less arguments you have, the more reasonable it forces the parties to be, because their lawyers are telling them, look, you've agreed to X, Y, and Z. So if you can't afford to pay for the shares, why don't we just say that and just ask for a longer promissory note period than what's put forth in the operating agreement, and then what it does is it not only sort of sets clear guardrails, it also it's kind of like buying insurance, so that 10 years down the road, when you are angry at each other, you're not able to sort of it sort of forces you to come to the table and be reasonable. So
it sounds like, Anthony, that if you own a business and you are getting married or contemplating marriage, you probably need to look at your partnership, limited partnership, because we're not talking general, get that out of your vocabulary. Limited partnership and shareholder agreements. And if you actually have other people who are involved in your business, in other words, it's not just you running a family business, so to speak, that you might everyone might want to have a conversation to review them, and maybe they want to add in a provision that says, in the event of a divorce of any of the partners or shareholders that are equity, maybe not if you're, or maybe even if it's controlling, maybe you want to say it's if you have a controlling, if you're a minority, maybe it doesn't matter, but if you have a controlling interest, maybe that's more important. But you might want to sit down with at least the equity parties and have a conversation about, do we want there to be a provision in the event of a divorce or other event, but we're talking specifically about divorce. And what does that trigger? What happens? Exactly what you talked about. Does it mean you forfeit your shares? You're bought out at X dollars. Your interest is valued or limited to Y. And amongst the parties that can occur, I'm familiar with law firms who have such provisions, and those have generally been enforced. So, it sounds to me that even before maybe the family lawyer, maybe you want to have a conversation with the business attorney who prepared your incorporating formation documents, and see if maybe there should be a conversation at that point.
And Carolyn, at the start, I know at the start of a divorce proceeding, you go through that deep dive on assets and liabilities. I presume you do the same when you're being approached for a prenup, or in a more rare case, a postnup, where you sort of get the lay of the land with respect to what the assets out there are and how they all would interact upon a split of the marriage.
Yes, we do. I mean, or at least we attempt to. I mean, certainly in a divorce and a prenup, we attempt to do that and to have the conversations, but sometimes people are so very happy about their impending nuptials that they tend to gloss over certain things, which really results in them having much more difficulties later on.
And that was going to lead to my next point, general, be more thorough than not thorough when talking to your lawyer on these, even on these issues that sort of, may not matter, because they will matter later on. And, it happens all the time that I have clients bring something up at the 11th hour, and I'm like, well, where was this agreement? Where was that? Where was this provision? You're trying to get X, Y, and Z, but you clearly signed something that says ABC, so, you can, we can fix most things on the front end and have those addressed, when they're addressed. Insofar as, making sure that, you understand, what your spouse is going to be undertaking, or what they're currently in, that's going to be important, because those have, big consequences. I'll note that in general.
Erin.
Yes.
Sorry, I'm having technical issues because I'm at court at the moment, and so my internet comes in and out. But Erin, from the standpoint of a financial professional, what is it that you see that the parties, or a business owner should be providing to the experts who are going to work with them?
Yeah, absolutely. And the most effective way to protect.
I'm going to turn my video off and see if that's better. I apologize, everyone.
You're good. The most effective way for us to protect our businesses is to be as proactive as possible. So before marriage, and I'll get into during marriage momentarily, but as Anthony and Carolyn were saying, of course, having a prenuptial agreement is very important. If you do not have a prenup, maybe you're considering a postnuptial agreement soon after marriage. It is very important. And that's really going to ensure the finances from the business will be kept separate from the marital finances, right? And that's important to understand. So before marriage, before you're entering into all the complexities, in New Jersey, businesses established before marriage are typically considered separate property, right? There's no automatic subject to division in a divorce. However, during that marriage, business is hopefully going to increase in value and can be subject to equitable distribution. So one key factor in determining the extent of that distribution is how involved that non-owner spouse was in the business, or perhaps was not in the business. So those are some things that the court might consider and factor in when thinking about dividing the business. Was the spouse's level of involvement, respective contributions, and that's financially or perhaps in terms of labor, future earning potential. During the divorce between joint business owners, spouses might arrange a buyout, right? And there's a lot that I can go into within that, but having some kind of co-ownership agreement is really, really important. It's going to outline each partner's rights, responsibilities, decision-making authority. It is crucial to establish that clear framework on how the business will operate moving forward. And again, as proactive as we can be before marriage is only going to help us if this ever does come up down the road. So if you are considering a buyout, right? Again, knowing the marital assets, real estate, investments, retirement accounts is very important. This can help you either retain full ownership, control the business while you're ensuring that ex-spouse receives a fair share of the overall marital estate. And as mentioned earlier, the business valuation is really crucial in this process. And I work hand in hand with CPAs and business valuation experts who are going to help appraise the business's worth. And as mentioned again earlier, at time of marriage and every 3 to 5 years, I recommend that the business should be appraised just so we have a baseline to go off of. And you have an unbiased assessment of the business's worth, revenue, assets, liability, potential for growth. And again, working closely with a CPA and your business attorney within those. And having those conversations on a regular basis, not just when something goes awry, is really important.
Erin raises a good point that, you know, if you are involved in what we colloquially refer to as a mom and pop business, and it's the two spouses are running the business, having a document, whether it's the shareholder agreement, whether it's the prenuptial agreement, I think it should be both agreements. If you have the luxury of, at the time you enter into the business and before the marriage, that will determine valuation, who keeps the business, you know, who is it? I mean, if this is truly both of you are equal partners doing equal work, that's harder, but typically the business is not that way. And one of the parties is really the one running the business largely through their efforts. And so the idea would be, in the event of a divorce, that person retains the business, but must buy out the other person. And again, determine how you're going to do the valuation. That eliminates a fight that we have in family court about that issue. A judge, we don't have to decide that, Judge. I have the shareholder agreement, the partnership agreement. Here's exactly what it says. So that issue's done. I don't need you to make a call. It's all good. And the other piece might be to say, you know, maybe there has to be a provision for an allowance of the other partner who is now not going to be involved in the business and probably drew a salary from the business. Hopefully they did. And to go find other work, and how much time might be reasonable. Is there an interim payment, like a severance payment, that is to be made for a period of time? Are they going to apply for unemployment? They may not be able to, so those are things that have to be thought through and can all be dealt with in a shareholder or a partnership agreement, and will eliminate arguments in the family court, because the two of them with lawyers signed a document. And I would say, if it's going to be, a partnership or shareholder agreement where they're each going to sign it, and there are potentially contentious issues to be discussed, they probably should each have their own lawyer. That will certainly lend more credibility in the event of a divorce if it's not the same lawyer. Sounds like a lot of work, but it's not, if people can think through it and have really good professionals talk to them about pros and cons. And then you, at least at that point, you have an assessment better of potential risks. You're calm, you're calm-minded, you're calm-headed, nobody's emotional, and you're trying to make business decisions. And so, You know, if everybody feels like they're being treated fairly, there's less likelihood for an argument when the divorce occurs, and less likely you invite a family part judge into your business, which is probably never a good idea. Because again, they're lawyers, not forensic accountants, CPAs, tax professionals. So they'll make decisions, but they don't have they have a law degree and life experience, and many of them didn't do family law. And they may never have done corporate, business, tax, or any other area that might be of assistance to you in that endeavor. So again, it's why I strongly suggest an arbitration provision, and pick your arbitrator and keep it confidential. Pick the right people to help you make those decisions if you need to. So let's talk about, real quick, let's talk about what we're already married. And I have this, I'm going to get her name wrong, but Joy Mangano, and I have developed this really fabulous little product that I'm going to sell in QVC and make millions, but I'm already married. What do I do then? Because there's no prenuptial agreement. And I will tell you that at least in New Jersey, there is a document, a form of agreement that is referred to as a postnuptial agreement, and everyone seems to think that that's like what a great idea, and won't that be helpful? Well, I'm gonna tell you that postnuptial agreements are void at law in New Jersey. They are unenforceable at law, maybe not void, except exceptional circumstances, which is really hard to prove. So I don't particularly like drafting them. I have probably drafted one in my career, over my advice to the client not to bother to do it, but they insisted. So what else can we do? And this is an area that I truly think that when the documents are being formed, providing the spouse with an expert, right? Or sorry, providing the spouse with an attorney and including provisions within the formation documents, which is not often done, but can be done, is particularly helpful. Anthony, Aaron, thoughts?
Yeah, so I mean, I think typically in my LLC agreements, I have a spousal consent, basically agreeing to the terms of the operating agreement, and they specifically note you've had the opportunity to have, to have counsel. You've either, waived that, or, you have reviewed with counsel, and therefore you're good to go. Again, you sort of write this and you give the proviso that, when it comes to the divorce courts, we can't really predict exactly what's going to happen. And just because you're signing this doesn't mean that, your spouse is not going to have a cut of this, but it's, something that sort of, you put in there with the hope that, at some point it'll show at least some acknowledgement that the operating agreement would control.
And do you insist that the other spouse, or do you insist that the spouse, the non-business owner spouse, have counsel?
I mean, I don't insist, but I recommend it. Obviously the more, the more the better. The more protections, the better. And that's, it'd be hard to argue something like duress or, being forced into an agreement you didn't necessarily want, when you have your own attorney. I think what ends up happening is a lot of times, especially with a startup company, funds are limited. And people are, well, I hired you. Why would I hire someone else for my wife who's not even going to do anything with this business?
Okay, but I can answer that. So the answer, I mean, my answer as the divorce lawyer would be, okay, but there are provisions in here that may govern what happens in the event of a divorce, or valuation, methodologies of valuation that the parties have all agreed to, that you may not agree to in event of certain events. So I think it's particularly important for you to, again, depending upon how much you can put into the formation documents to protect the business owner spouse in the event of certain events, including divorce. I think the more I would, I probably would like to see either, that spouse have their own attorney, or be strongly encouraged in a letter writing. But I agree with you, people, when they're happy and they're in the beginning stages of formation, they may not want to spend the money, or they're just so happy that they're getting married that, I'll deal with that later. It's never a good answer.
No, of course. No, and I think that's well stated. And you know, a lot of times you'll find, so again, where this issue comes in is, not necessarily, Google, or, investing in Apple stock, or, a multinational company that may be private, but there's there's multiple layers of equity, or a huge, capital stack where there's incentive units and this and that and the other thing. Those aren't necessarily the concerns. It's generally, the smaller the business, the bigger the concern this is. Why? Because if you only have 3 owners who each own a third, if one of them loses their management rights to their spouse in the divorce, then that could be certainly a problem. Additionally, if they lose their financial or economic rights, they might just, disengage from the business completely, because why would you work without pay? So, or at least work with much less pay than what you would have initially been entitled to. So, this is where you're really going to find that concern. If you're, say, working for, a large multinational, they say, oh, here's some, incentive stock units that, they have no voting rights. They, but in the event of a sale, you'll get, an amount equal to 2% of the sale. Then you're not as concerned about that, situation. But it's when, the business can really go under, because you'll have someone who's inexperienced either take over or demand a huge amount in exchange for their shares for the buyout. That's, I think, the sort of parade of horribles that these buy-sell provisions are looking to prevent.
And I think the other part of it, and Aaron, you can probably speak to this as well, is, if you have a small business like this and one of the partners goes through a divorce and there is an exceedingly large amount of money expended either in the divorce or just in valuing the business,
Right.
You just, that person may disengage for that reason. And now you've lost a valuable partner who's now expended all this money and decided this wasn't worthwhile. So, you said, you work with CPAs and forensic accounting people who can do, valuation experts.
Right.
What ways have you seen that they can sort of minimize, or what agreements or provisions that, ways that they could minimize the financial impact of a divorce?
Sure. And I want to go back to what Anthony had mentioned, the buy-sell agreement. That legal document is so important in outlining, again, what life events could happen that could affect all of the partners within the business, how the business is valuated, outlining it, and how we're funding that agreement. A lot of times I see an agreement, buy-sell agreement might be in place, but it's not funded. So in an instance where it's not funded, that business owner that's not involved or is involved in the separation might have to go and try to get approved for a loan at a bank, which we don't know if you're going to be approved for that loan, right? Having a certain asset earmarked to fund that agreement to mitigate those expenses. If it's a disabling event or a life-threatening event, sometimes we will fund it with life or disability insurance. But in a case where, there is a divorce or separation, we would fund it with a specific asset that's earmarked on that business's balance sheet just for this kind of situation. So it's not going to affect the business to go in the red or not be up to their usual production. That document is so important to have in place and to be funded. It's a two-parter.
Yeah, and just to clarify, because even what Erin noted was, when we talk about a buy-sell agreement, that is basically, in general, are restrictions on transfers that owners of businesses agree to mutually. And, and that bind future owners of the company who, might acquire equity. So a lot of times, you'll have the buy-sell agreement drafted after the after the company has been formed, maybe you're taking on a new partner, something like that. A lot of times I don't have a separate standalone buy-sell agreement because I've either lumped those provisions that would normally be out there into a shareholders agreement that sort of covers everything, or or an operating agreement if it's an LLC. So, generally, I guess the way to kind of look at the Venn diagram is not all, all, I'm trying to think. Well, no, there's no Venn diagram. Forget that. Sorry, I was trying to get too creative by half. But in general, a buy-sell agreement doesn't have to be limited, but a lot of times you're going to find those provisions in an operating agreement, in a shareholder agreement. So if someone says, if someone says to you, do you have a buy-sell agreement? And you say no, but you have an operating agreement or a shareholder, look to that to, before, really making that final kind of assumption when going forward or when making a decision involving your property.
Okay. And Aaron, what are some of the financial considerations in a divorce if you own a business? Forget the legal or, ignore the lawyers in the Zoom and, and tell us what you, in terms of the business owners that you have worked with, because a substantial portion of your practice, if that's the right way to say it, but your business is with business owners. And so, what are the financial considerations that you see that should be considered and potentially addressed in the anticipation of a marriage or potential divorce?
Great question, Carolyn. Thank you. So to go from a very high level overview, when working with business owners, really important to me is protecting, growing, and eventually helping for exit planning within the business. So first and foremost, in protecting the business, we want to make sure from an insurance standpoint, whether that's property and casualty insurance, life, health, disability, group benefits, that's in place. Legal documents are in order. I take a very holistic approach. So looking at all of these components are very important. I am not an attorney, so maybe in my next life I can be. But advocating for my business owners to say, hey, do I have the right liability limits in place? Do I have the right legal documents in place? Maybe there was one done 18 years ago and it wasn't updated. Let's talk to Carolyn. Let's talk to Anthony about that, right? All right, saving and growing the business in the most tax efficient way. Those are conversations that I'm having on a daily basis. But if we're talking about from preliminary determinations, how within a divorce, right, the court is going to view the business and what that interest is considered. Is it a marital asset? Is it separate property? A couple of preliminary determinations that I see and that we should think about, right? Understanding the source of funds. How did the business get acquired, right? Where did it come from? Who's involved in that? What were financial contributions made throughout the years? Perhaps personal efforts that were contributed by the business, either spouse during the marriage. And I want to have those conversations with both business owner and spouse. And again, understanding how the business has been valued. What is the fair market value? And the three big ways that we can value those are either by an asset approach, market approach, or an income approach. And walking through with those business owners, well, what does it look like to buy out? What does a buyout look like? Is it best to sell the business? Maybe they remain co-owners, which I rarely recommend and rarely see implemented. Really the first two, buying out other spouses, selling the business. And I, as the financial advisor, am there to help test stress each of these strategies. What makes the most sense from a tax, a loan perspective, if need be?
And if you're going to have them sell the business, because I've certainly dealt with that in some of my cases, the parties both mutually agree that if it's not going to be them working it together, it's unlikely that one of them can stand it alone. They've reached an age at which it's okay, let's sell it, make some money, retire, do something else. And so how do you approach that issue in terms of, do you engage a business broker, or do you talk to someone else about what the value might be and then how to address the sale.
Great question, Carolyn. So I do work very closely with business brokers. Sometimes I will ask the business owner, hey, what is your EBITDA? And I get a blank look or a very inflated valuation. So it is, again, very important to work with unbiased, a separate, professional to help the business get a valuation done. Business brokers are a wonderful help with that. And making sure in that buyout, I'm looking at either the business owner or the other spouses. Well, how are we, if the business is valued at $1 million and Joe and Joanna each own 50%. Well, where is Joanna coming up with that $500,000 to buy out Joe, right? How are we funding that? What is that going to look like? Is that coming from a retirement vehicle where there might be a 10% penalty and income tax on that? Does that make sense to do? Can you qualify for a loan? What source of funding is that coming from? But I think first and foremost, having that independent valuation done is so important before even talking about selling and the buyout, what that looks like.
And the reality is with the right professionals, you can get creative about that because, if you're
Absolutely.
going to use retirement funds to buy out an interest in a business, one is pre-tax, one is post-tax. So how are you going to treat those? You can't, it's apples and oranges, but you can certainly do that. If there's $2 million in an IRA and $1 million is what she would receive, then maybe she receives less, or maybe she's going to keep the business. And that's why it's important to have a financial professional and lawyers who are also involved in the business do that. Because, one of the other things, and it doesn't come up often, but I've had, instances where someone is an equity position in a business and they are not, and it's a smaller business, and they're not entitled to divest themselves of any of the shares that they own in the business under the terms of the operating agreement. So they must maintain a certain equity position in the business. And that becomes tricky because, again, then you have to see, is there another way that the spouse receives their value? Right. Because you aren't going to get it from the company. You're not, let me be clear. Nobody wants to implead a company into their divorce. Right. Not a good idea. And so, if you have operating agreements that govern some of this, that it may hinder your ability to do this as simply and cleanly as you think it might otherwise be. So I think that's another thing that people need to consider. And, we touched on this briefly, but let's talk about it a little bit. The three of us, what documents, if anyone is trying to do either a formation document, Anthony, or at whatever point in time, but particularly if there's a marriage, considered, or a spouse involved, what documents do you, as the attorney drafting the formation documents, want to see? And I'll throw one out there. Do you want to see if there's a prenuptial agreement?
So, I mean, that's a great point. I generally wouldn't ask. Well, I guess, no, I don't think I've ever asked for one, to be honest. I think it makes sense to the extent that there might be a concern that, hey, me and my spouse are probably about to divorce, or, it comes from another partner, which I have heard before. People say, all right, look, Bob's about to get a divorce. Like, how do we protect the business? And that's generally where we see this. Look, there's a hidden incentive for most people to be reasonable, because if you torpedo your spouse who owns part of a business, if you torpedo their financial prospects, there's less money in the pot for you when you're getting your equitable distribution. But in general, no, I don't think I've ever asked for anything like that. I've had people ask me to either refer to a family lawyer for the sake of doing a prenuptial agreement, to reference the drafting of a postnuptial agreement. And this occurred mainly in Pennsylvania, which I can't really speak to whether or not it was enforceable, but there was a family lawyer brought in to do that. Or for mine, I just kind of have this spousal consent there that, you know, has them sort of agree to join to the operating agreement. So, I mean, in general, you know, the agreements that are going to, you know, I guess by way of background, the agreements that are going to occur when you're forming a company depends on the company that you're forming, right? So if you're forming an LLC and you're by yourself, you kind of really don't need anything. You have an operating agreement in place because the bank wants to see it and they want to confirm they want a signed writing by you. Basically, it says I'm the only person that can make decisions here. If you have more than one person, you're going to have an operating agreement that's a little more fulsome. You know, if you pull something off of, you know, say, you know, off Google or off, you know,
YOLO.
Zoom, Zillow, yeah, anything like that, you know, you might be challenged because a lot of those provisions in there are fine, but they're very basic and they don't take into account the different changes that occur you know, upon death, disability, this and that, because that's not really what they're meant to do. They're sort of meant to hit, you know, the basic points that are going to generally, you know, cause you an issue. And that's that. And the benefit of an LLC is always that it's a, you know, LLCs are sort of creatures of contract. Yes, there is, you know, there is a, you know, a statute that covers LLCs in the event that there is no operating agreement. Or that in some cases override the operating agreement in very specific, not particularly, like you can't waive the duty to be honest with your partners. You just can't do it by statute. You know, but the operating agreement can be as flexible and as deep as you want it. You know, so that's you know, a huge benefit of the LLC. If you're forming a corporation in general, you know, you're going to have, you know, your articles of incorporation, which, you know, is what you're going to file with the state. You generally find articles of incorporation to be a little more complex than name, rank, and serial number when you bring in investors and have what are called preferred interests, because you want, you know, the preferred investors want their rights out there front and center. But, you know, typically in a smaller company, you're not going to see that. You know, you'll see one page on a Delaware LLC. Same with a New Jersey LLC. Then you've got, not LLC, sorry, corporation. Then you've got your bylaws, which a lot of people think sort of operate as the operating agreement. I know I did 6 months into being a lawyer until I realized otherwise. But basically, your bylaws are just sort of almost like the bones of how everything, you know, works. You know, how long does a director serve? How long is this? How long is that? What happens then is, you know, for more closely held companies, you're going to have what's called a shareholders agreement, and that shareholders agreement is going to operate as a you know, it's very similar to what an LLC operating agreement is going to be. So that's, you know, so that's where you sort of can insert contractual principles into the shareholder relationship. Things get complicated if you, you know, admit people as shareholders, but don't have them join to the shareholder agreement. So, but, you know, of course, we can deal with that at a different time. You know, and again, what you need to be aware of when you're looking at these agreements is, are there buy-sell provisions in these agreements? So do they just, you know, say this is how a partner or a member can be sort of terminated as a member? Is this how a shareholder can lose their voting rights? Is this how someone gets kicked off the board? You know, it could just, you know, I've seen a lot of operating agreements that sort of just function on the nuts and bolts of how big decisions are made, and that completely ignore what happens in the event of a death. Well, what happens in the event of a death is, if you don't have an agreement, the person's estate takes over, and that estate is going to operate through an executor. And what does an executor need to do? An executor needs to dissolve that estate as soon as possible. So, you know, you might have now a trust is involved, and now you have a trustee, and things become a little more complicated, especially when you know, if you're trying to run a business. So what happens is a lot of prudent financial planners, like Aaron, will say, hey, you know, I saw your operating agreement. You might want to have a lawyer draw up a buy-sell agreement to accommodate a situation where, you know, these, you know, 4 things, you know, I kind of call them the 4 Ds, you know, death, disability, divorce, and default. So you've, you know, committed a crime, so now you're going to get booted, and how do we address that? So that's a
Yeah. You know,
that's
you know who your partners and your shareholders are going in, but you don't know what happens when they disappear for whatever that reason is, and you do not want to inherit, no pun intended, a new partner or shareholder that has not a clue about this business, how it runs, how it ran, what it is, and making all sorts of demands of the business that become very, and in some cases, very cumbersome and interfering with the business. I mean, a good, a good, a bad, I'm not even sure what the right term is, but, in the event of a divorce, the production of documents relevant to that business can become onerous. And now you have somebody at the business who should be doing invoicing, now spending 90% of their time trying to gather documents, many of which are probably unnecessary, but are going to be asked of the spouse in the business and the business. So, Erin, what do you think that, what do you think should be? And by the way, the other question I was going to ask you, Anthony, and we did not pre-script this. In how many cases do you see there's a shareholder or partnership agreement and zero bylaws?
I'm sorry, can you say that again real quick?
Sure. And how many cases where you have seen, not where you've drafted, but you've come in after the fact, have seen that there is a shareholder or partnership agreement, but no bylaws?
So that generally doesn't come up. I've had situations where there's no partnership, no shareholders agreement, and no bylaws. But generally what happens there, of course.
I have that now in two cases.
Yeah, and sometimes shareholders agreements can operate as bylaws because they do have because basically what people do is, they're so used to drafting operating agreements, they turn their operating agreement into a shareholders agreement. And so they might cover what bylaws cover. Typically what you'll find is in those instances, you run into trouble because the statute doesn't necessarily match what the intent of the parties are. And, I've had instances where, we begged a client to amend their bylaws in a very specific way, and they wouldn't do it, and things just got incredibly complicated. And we were essentially, and we said this at the outset, we were like, look, here's a path where you're going to avoid a lawsuit, but unless this guy has no money whatsoever, he's going to sue you. So whatever we do, we are not going to avoid that. So, the way to have avoided it is, 5 years ago when you started the company, was to have a good set of bylaws and a good shareholders agreement. But now we're here, we have this.
And Erin, sorry to interrupt, but we have like 7 minutes, and I do want to ask Erin, so from the financial planner's perspective, and we have a question in the chat that I'll get to. I'm not sure it's entirely really what Erin but we can banter that at the end.
Sure.
What documents are you telling your business owners to gather proactively, even for their divorce lawyer, so that we minimize this gathering of the information, time, money, effort, and otherwise?
I'm a huge proponent of financial document gathering. From the second meeting I meet with clients, whether they're going through a divorce or not. So I already have a majority of all of these documents. But specifically in divorce cases, a couple of things that I want to have gathered, reviewed, and organized, including current statements of bank accounts, so checking, savings, credit cards, investments, retirement plans, documents relating to loans, income, tax returns are huge. The last 2 to 3 years tells me a lot, will tell about the business significantly. Any titles to property, home, cars, boats, you name it, insurance policies, there might be key man, key woman buyout, perhaps health, long-term care policies in place. Those are really important to have, as well as once you're getting through the process, but updating beneficiary designations is huge. I've seen so many times business owners either forget to update those designations, change them from an ex-spouse or a current spouse or business partner. Really important on insurance policies, IRAs, annuities, retirement plans. to have that in place. And of course, eventually updating your estate planning documents, your legal documents, your operating agreements, your buy-sell agreements. Of course, I want to see shareholders' documents, and even bills, making sure your bills
Appraisals?
stay updated, appraisals. That's a huge one as well. One that people might not think about, or neglecting bills, but that can affect your credit score throughout the divorce process. So that is equally as important. Paying your taxes on time, and again, the tax returns being filed on time throughout this process are equally as important.
Okay, and so here's the question that was posed by one of the watchers that's sort of related to this issue with businesses, and it comes up all the time. I'm gonna phrase it as perquisites. The question is, Erin, how do you typically reallocate personal expenses that have been paid through the business and written off as business expenses? And so we in the family law arena refer to those as perquisites. They are, let me say this first, they are perfectly legal to do. They are not a tax violation. I cannot tell you how many people come in and say they're committing fraud. It's a tax violation. They're committing fraud. I'm reporting to the IRS. I'm like, no, it's perfectly permissible to write off a portion of your car, your entertainment expenses, your phone, your uniforms. Those are perfectly legitimate from a tax standpoint.
Yes.
But they do implicate, at least in family, the way we look at it, cash flow, because you're putting it through the business and it's being written off as a tax. So you're not spending it out of your personal pocket, right? So how do you try to first question, do you work with business owners to segregate those, or to start to look to see what those are?
Yes, this is a great question, Sandra, and I see this very often, not only going through the divorce process, but more importantly in the exit planning process, when we realize, wow, look how much the business is quote unquote paying for that's not coming out of our personal checking account on a monthly, quarterly basis. Wow, we're going to have to start paying for, insurance and the cars and the phones and everything else. So I think a good way to start is understanding, well, whose expenses are these? Who's mostly paying for the auto? Who's mostly paying for the entertainment, for trips, what have you? Trying to separate that out initially is a good starting point. And I see this, I would say maybe 90% of the time. It's very often because business owners try to run as many expenses as they can, and as they are allowed to do so through the business. So I think having a conversation first and foremost of who is running most of those expenses through the business owner, that the non-business owner spouse, might not be privy to take on as much as the business owner spouse would be on the personal side. But I see this very, very often.
I agree. And I work with either, accountants or financial planners to sit with clients and literally go through what's called a case information statement and say, okay, now tell me, how much are you spending on auto insurance? And is this being paid by the business? And I will indicate that, because to me that it's an expense. It's just not coming out of your personal pocket. So I think it's really important if you are actually in both cases, to get an understanding of what that is, because it will have an impact. So any final words? We have like a hot minute and then we are done. So any further questions? I don't see any. Any other comments? It has been a pleasure, Anthony and Erin, as usual, to banter and discuss these issues. And we could certainly talk about this for way more than an hour. And probably come up with even some additional thoughts, but it was great to get an hour and be able to talk to, those who have attended and give them some thoughts, and to think about. And if you have any questions, please reach out to us. I mean, Anthony and I have our email addresses on the website. Erin, Erin is.
Put mine in the chat as well.
Erin will put hers in the chat, but you can also locate her through her work. Look at this. She's already on it at Cannon Financial Services. So anyway, have a great afternoon and thank you all.
Have a good one.
Thank you all.